is the zoning board of appeals, a regular meeting, April 19th, 2018, 7 o'clock. On the agenda tonight is call to order, approval of minutes of February 15th and March 15th. Vote to approve or withdrawal form of case number 1809, and public hearing scheduled for 710 Railroad Avenue and 745 Weathersfield Street. At this time, I will call the meeting to order. First item on the agenda is the February 15th minutes. Motion to accept the minutes as read is presented.
I'll make a motion to accept it as read.
A second.
Motion's made and second to approve the minutes as presented for February 15th. All those in favor signify by saying aye.
Aye.
Aye. Okay. Minutes of March 15th. All had a chance to read both of these. If so, I'll accept the motion to accept these minutes from March 15th.
So moved.
Is it seconded?
Second.
Motion's been made and seconded. All in favor, signify by saying aye.
Aye.
Aye. Okay. Okay, we have before us a request to withdraw Diane Smith at 228 Main Street, Raleigh. She states, "I wish to withdraw my application from the Raleigh Zoning Board of Appeals without prejudice." This is case number 1809. And as you recall, she applied to convert the house to a two-family, and she has since sold the house as a single-family home. So there's no need to make it into a two-family.
Well, the only problem is that we found out she'd already sold it before she came here.
Right.
Public record indicated that. And we voted, I believe, to dismiss it. And she wants it dismissed without prejudice, and I'd like to see it dismissed with prejudice.
I agree. My comment would be that this was an applicant that at the time she actually submitted her application, the property was under her control as an owner. But that was December 20th. But on December 31st, she sold the property.
No, she didn't.
That's what the deed says.
Yeah, it's on record.
It's on record. So she came into here on our hearing on the 18th. Will, as near as I can.
Have you seen the deed?
Yeah, I did. Yeah, it was
It's
I looked at it.
online. We both went online.
We went to the registry of deeds.
Well,
The night she came in here, she'd already sold it. It was on record. And we mentioned that when we said we thought it should be dismissed.
I beg to differ with you. She did not sell that place till the end of January.
Not according to the
Okay,
signed deed.
That's my memory. I'd have to look at it again, but there's a deed that, my memory is, and if I'm wrong, of course, I'm happy to admit that, but my recollection is we looked at the registry of deeds, and there was a deed already on record before she came in here.
We didn't discover that till after the fact. I think the only relevance here is that, I mean, she doesn't even control the property. any longer. So whether or not we dismiss it with or without prejudice actually doesn't affect her, because she's an applicant, can never apply for anything under that property again. But I still think, you know, she came before us, she put the board through all the work, we did all the review, we actually prepared a decision. There was no need for the board to spend any of that time. And I wish she had been more forthcoming with this.
Well,
Well, I won't vote on unless we see something in paper that it was
I have
done that way.
sold on February 1st. That's what I have.
From whom? Where do you have that from?
Is estimate? No, that's not.
I'm talking
I
about.
printed it off some site.
Yeah, but the official record is the registry of deeds.
Right,
I don't wanna, if it's gonna become an issue, I'll just vote to allow it, but
yeah, I don't have a problem with allowing the withdrawal. The case is
Yeah,
moot.
I mean, let's get it over with, I mean,
It's a dead issue anyway.
yeah.
Right. I agree.
All right, so you want to withdraw it with prejudice?
Yeah, I think that's more appropriate.
Okay. Okay. All right, so you want to make a motion?
I move that we vote to accept the request for withdrawal as amended to read that the application be withdrawn with prejudice as opposed to without prejudice.
Okay.
second.
Okay, motion's made second. All those in favor, signify by saying aye.
Aye.
Aye. The record show that we voted it with prejudice. Okay. And I signed it. I crossed off. Okay.
Okay.
Next case is American Barbecue. At Barbara Wood Avenue. Let's get it, what?
7:10.
10.
Mr. Chairman, the architect is, I just saw him pulling around, so he'll be involved.
I don't wait. I would wait.
engineer. I wasn't at the previous meeting. He is literally around the corner, but I could step in if you'd like to start the proceedings, Mr. Chairman, or we could wait for him. I apologize.
You are,
Excuse me?
you are,
I'm Dan Ottenheimer with Middle River Consulting.
you what? I'm sorry.
That's okay. The project architect for this project is Bill Nolan, and Bill is on his way. He'll be here in 2 minutes. I'm the project engineer. He's been most familiar, and he met with you last time. So whatever the board would like, I could initiate a presentation, or I apologize, or we could wait until he shows up, whatever
Okay, I
pleasure
got
of
a
the board
couple of
is.
things I need to read, so
Okay.
I can do that. Okay.
Okay, okay.
Okay, we got a letter from the planning board regarding 5 Railroad Avenue American Barbecue. And I will read it. At its meeting on Wednesday, April 11th, 2018, the planning board decided that while it is amenable to the zoning review comment on any application before the ZBA, it is up to the ZBA to conduct a comprehensive site plan review pursuant to the requirements of ZBL Section 7.6, Section 7.6, and to specifically apply the review criteria outlined under Section 7.6.3. The planning board members have determined that such a comprehensive site plan review is warranted in this case where the expansion of a commercial non-conforming use may potentially impact the abutting residential uses, and because a special permit review necessitates the site plan review as stated under Section 7.8.1.2. One element involved in formal site plan review is the option given to the appropriate reviewing board, in this case the ZBA, pursuant to Section 7.6.4.3, that such board may engage in the services of a professional consultant to obtain an independent review of the site plan, and that the costs are required to be borne by the applicant. Thanks, Kurt Baker. Okay. Interesting. On Thursday, April 5th, 2018, we made a site visit to 5 Railroad Avenue. And in attendance was myself, Tom Heigard, Bob Gould, and Donna Thibodeau. And the project engineer. And these are all emails, right, Lisa?
Yep.
Okay. From Mike Savoni, he wrote, I hope you enjoyed your holiday. Lisa's ZBA meeting requested an existing site plan showing the exterior dimensions of the building. An updated drawing is attached for them. They also wanted to set up a site visit before the next meeting, and they said they would be in touch regarding the scheduling of this event. We have not yet heard from them, and wondering if you were able to give us an update as to when they might set this up, and also what the exact date would be. And that was on April 5th that we did that. But we have an updated plan that shows all the dimensions that you were interested in primarily.
I wasn't here, so what are they actually doing here?
Okay. Okay, you weren't here, okay. They, putting a new ramp down here, a new entrance in here. They're gonna basically do this. Over here. The only, it's not gonna impact the parking whatsoever. There's picnic tables in here, it comes across here like that, the building. And, we're gonna, here like this, and tear this, basically, gonna tear that all out, and rebuild all of this. New entrance comes in there. And, we can try to simplify. They have a liquor license.
Yeah.
Okay.
Okay. Okay.
Is that what you want? Yeah, no, that's fine, that's good. I'm not gonna do all the calculation, I'm just gonna write them over.
Going back to this letter from
Let's go back to June.
the planning board. I don't know. Very honestly.
What are you concerned about? What are you concerned about?
Under section 7.6.3, it says the applicable board shall evaluate the site plan on the basis of the following criteria: protection of adjoining premises in the neighborhood from detrimental impact resulting from the use of the subject property, including creation of a nuisance by virtue of noise, odor, unsightliness, vibration, and the light trespass. Convenience of safety and vehicular and pedestrian movement within the site and in relation to adjacent streets. Adequacy of methods for water supply, sewage disposal, and surface drainage. Adequacy of off-street parking and loading areas. Signage and exterior lighting and visual impact of parking, storage, and other outdoor service areas. Consistency of the proposed development with the character, scale, and design of surrounding buildings. Adequacy of landscaping plan, including the use of natural land features, plantings, and screening materials. compliance with the provisions of this bylaw. Adequacy of all required documents such as easement and condominium documents to assure the maintenance of buildings and structures and public and common lands. Adequacy of the measures proposed by the applicant to buffer or screen any commercial activities or structures shown on the site plan from nearby residential neighborhoods or residentially zoned areas. That's what we're dealing with. And it's also requesting section 643. The appropriate board may engage in services of a registered civil engineer, architect, landscape architect, traffic engineer, planner, or other professional consultant to obtain an independent review of the site plan. The cost of such a review shall be borne by the applicant. All right, that's that. And it's 72812. The special permit granting authority shall review the special permit application in conjunction with a site plan filed under section 7.6. Okay. I don't know if it's really necessary for us to go through all of this in this particular case.
Mr. Chairman. I think that the planning board assumes that it's us that has to do a site plan review.
That's correct. That's what.
Whereas at the last meeting and at the site walk, I think we all thought they were going to do that because we reviewed it in the context of the very narrow application for a setback in that one context. So we've done
Right.
a site walk thinking we were looking at one thing. They're saying they think we have to have a much broader approach. And I don't know, I mean, I'm just seeing this for the first time. I agree with you that considering the fact that it's an existing use and the use isn't being expanded really.
Right, right.
But I believe we all thought that the planning board was gonna do a site plan review, if at all.
Right.
So, isn't the first issue, do we agree a site plan review is even necessary, and if so, who does it?
Well, whereas they are asking for relief for zoning, the review goes to us.
Okay, I
Okay.
mean, this
That's,
is, yeah, I mean,
that's the way I understand it.
okay.
That's the way I understand it, because our permit will, so it's whether we want to go to a full-blown site plan review, whereas my feeling on it is, with the building has been there, he's only encroaching, he's not encroaching any further than it is right now.
Right,
It's just,
Yeah, I agree.
he's adding an addition, which is gonna take up where the picnic tables were.
yeah,
And, so the site isn't gonna change.
I guess my question is simply, does the mere fact that the planning board says they want a site plan review mandate it, or can we say, we don't think it's necessary.
Yes, you can say that.
Yeah, I don't think it's necessary.
I spoke,
What,
I'm sorry, Mr. Chairman, I spoke to the planner, and
Yes.
he did say that it was up to the ZBA whether they wanted to do it or not.
okay. Okay. So. I feel that what we actually did on the fifth was adequate for,
I agree.
that's my take on it. So, your motion was to, not do it?
Yeah, I would move that we vote that a full site plan review is unnecessary in this case.
Okay.
I'll second it.
Okay, motion's made in second. All in favor?
Aye.
Aye. Okay. We're taking care of that. Okay. Okay, so, one of the questions that we had regarding this, was the area inside the building. Can you,
May I approach?
Yep.
So, at our last meeting, I'm not sure if this is what you're asking, at our last meeting, you asked for some dimensions so that you could go through the math if you chose to substantiate the number, because we are approaching the limit of 7, of that limit. Is that what you were asking?
Yep.
Yeah, so we gave you the information,
Right.
is that to your satisfaction?
right,
If you didn't by any chance actually do the calculation yourself.
Yeah, well, we had done the calculation.
Before.
Yeah, before, and the numbers were the same. It's all in the computer, so
yeah, okay. All right.
the number was the exact same.
What was the numbers?
It's 910 square feet being added, which is within, I believe, the 25% expansion.
That's
We're
the
right at
ratio.
it, yeah, we're right at it.
What's the total area presently?
Total area presently is 636
3650.
of the entire building?
Of the whole building.
Yeah, I'm sorry, yeah.
The whole building?
3,650.
How much?
3,650.
Okay, and you're gonna wind up with how many?
About 910, 910.
910 more.
Yeah.
Right. So that's where it fits into 25%, it's right on the mark.
Yeah,
No.
it's in our intention to stay within the 25%.
Right, yeah, okay.
We would have had to make it your intention if it wasn't.
Yeah, sure.
And we're willing to.
Yeah, if you want to put that as a condition, that's fine.
No, you're in it, it's clear, you know.
Okay.
We'll try to avoid as many special permits and variances as possible.
Okay.
You should probably recognize that since we have elected not to do an engineer-driven site plan review, that you may be exposed to that by the planning board, since you have to go to them to finish up.
Yeah, so the owner, Steve, actually has retained Dan Ottenheimer from Mill River as a site engineer, and he retained his services to go through and review the site planning information. So we have that on board, and we're doing what we need to do.
That's fine, that's just more of, a cautionary note
Sure.
about a
Yeah.
proceeding, because
Yeah.
there may be time associated with that we'd want to factor in.
Right, and it is our intention to follow up with the planning board, and whoever else we need to follow up with.
Okay. Anything else we need to ask them?
Any other comments on the application from any abutters or other attendees?
Are there any attendees here of Railroad Avenue
Case?
have any questions
I don't have any questions.
or concerns?
I think it's too big for the community, for that area of the neighborhood. It's too big. That's my comment.
Could we have your name?
Yeah.
So
Kath-
Lisa?
Catherine Haley,
Okay, great.
I've spoken to Lisa before.
Okay, I have no other questions.
No, I have no other questions. On the site visit, your change as proposed barely modifies the site at all. It really simply reutilizes existing area. And were it not for a foot or two encroachment on the setback, there would be no need for you guys to even be here. So in terms of it impacting the physical site, there's really no change to the areas that you or I can or can't get to, or that traffic can or can't get to. It does increase their capacity, certainly a little bit, in terms of expanding seating area, but he's not increasing the parking area. He's not asking to do that. So a lot of the proposed impacts, I think, are simply so that he can get more people in a car to come there and participate than he's actually gonna draw more. You can't get in a parking lot, you're not gonna drive around and sit. It's not that kind of
Yeah,
situation.
it's just a very awkward lot.
It is.
And there's a residential home right smack dab in the parking lot.
Yeah, no, it's a very unique lot, and when anybody who's been there knows that, and when we walked the site, we noted how, it's a U around a residential site, but there's none of that that's in violation of anything, and where they're putting this is exactly where stoned area exists in front of the building now. It really, it almost doesn't encroach. It doesn't encroach as much as this table into the setback area, so I don't have any problem with any of the conditions that would apply under the site plan. I think we can support the application as actually having met virtually all those conditions, both by observation and review. So I would vote to accept the I would move that we approve the application as submitted and draft an approval decision with conditions relevant to the site plan, conditions that are under 7631 for approval and signature at the next meeting.
I'll second that.
Okay. Any discussion of what Tom had to say? Okay. All those in favor?
Aye.
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 Good night, Jim.
Okay, great, thank you.
Thank you.
Okay, case number 1807. We have a note here from Tim Collier. Requesting continuance till May for the zoning board hearing.
I move we accept the request.
Tom's made a motion to accept the continuance till May. Here it's seconded.
Second.
Okay, move to second. I bet you, I'm gonna go to the okay, it's not quite quarterly. Marion Way, I'm gonna jump ahead, Marion Way,
Very last page.
last page. For Mr. Vakulis regarding Marion Way, request a continuance to May 17th.
I move we also accept his request.
Motion's made.
My comments should have been edited on the,
Yeah.
Okay.
I like the graphics. Is that name of the graphic? Is that name
yeah,
of the
well,
graphic?
no, well, it shouldn't be. Right.
I have to sign those requests, don't I? And they have to be submitted to the town clerk. Am I correct?
I'll have to check on that, because I haven't done it.
No, okay. Okay. I think everybody's here that's gonna come for the school, so. We received a letter from and you also seen a letter from, Lisa Mead regarding April 12th letter.
Yes, that's, yes.
Have you seen it?
Yeah. is it? Mhm.
Okay, I guess, you're supposed to be, getting a site plan review from the planning board.
Mr. Chair, Lisa Mead, Mead, Coleman, and Costa on behalf of the North Shore Montessori School on Weathersfield Street, as you know. And we were before the board in October, and we had discussed the use. The point of our being at the board was that the building inspector had issued a cease and desist for the use as an educational facility over the age of 7. That was the point. So we requested that the board overturn the cease and desist determination of the building inspector. There was a large discussion in October relative to the exemption under Chapter 40A, Section 3, as well as the exemption under the zoning bylaw in the town of Rowley, allowing nonprofit educational institutions to be used, or to be operated in town. This board, according to the minutes, and of course at the meeting that you were all at, were concerned about the circulation and parking as comments came from the audience and sent us off to the planning board to address those matters with the recommendations of Board of Town Council. So we went to the planning board. We initially went to the planning board. We received feedback from a peer review engineer. We received feedback from the fire and police chief. Before our first meeting even occurred with the planning board, we went out on site with the police and fire chief, and we understood what their concerns were. And we attempted to make those changes before our first hearing, but the planning board wanted to go forward, so we did that. After that first hearing also the concerns of the planning board as well as the peer review engineer, we had another site visit, at which time we incorporated all of the changes that were requested by the planning board, the peer review engineer, as well as the fire and police chief. I'm not sure, were you copied on the emails from the fire and police chief that say they're fully satisfied?
Did we lose? Yes, okay.
So, with a caveat, I'll get into that in a minute. But let me just tell you the changes to the plan, because I think that they are really important, and I think that they address some of the concerns that were made at this meeting with the board, not related to use, but related to traffic and circulation, which of course is a result of use. So, here's Weathersfield Street. The engineers have agreed that there's no site issue along Weathersfield Street. Currently, there's a very narrow driveway entrance here because there is a garage attached. That garage is going to be coming off, and there will be a slight mudroom here, but the driveway entrance will be the required driveway entrance under the new fire code of 20 feet. So it meets the fire code requirements. That 20 feet will continue all the way up into the site. There will be, right now there's parking back in this area of the site, but it's kind of gravel and not necessarily improved, but it will be an appropriate graveled parking lot back into the site. The fire chief wanted a T turnaround, so there's a T turnaround located here in case there's any fire apparatus that gets up there and needs to come out. At the very last planning board meeting we were at, the one member wanted to add a handicap space, and we had a parking space here initially, and so the peer review engineer wanted that moved. And so what we did at the peer review engineer's recommendation is make this turnaround deeper and add 2 parking spaces at the rear. The reality is there are only 6 staff members on site, and so the parking, even though we meet the parking regulations of the planning board, the parking isn't really necessary. So there's 26 parking spaces on site. So in any event, the peer review engineer suggested that they go back here, and so that's where they're located. So there's a turnaround, folks can come up, drop off their kids, which is what they do right now, do a turn, and then they come up and they drop them off, where am I, in the building right here, and they unload and go on out. So there's added parking here, and then there's 2 swing parking spaces here. Of course, the owner lives here, Margaret lives here, and she would use one of those spaces. She wouldn't use one of the ones in the back. So in addition to that, in addition to adding the handicap spaces out here, this will be one of the entrances to this building, an exterior door here. So the peer review engineer suggested that a metal rail be added along here so that kids coming in and out of here don't conflict with any traffic. But we originally had parking there, so now there's even a bigger sidewalk separation in addition to the rail. Additionally, there was some storm water added. There's a little rain garden that was added here. That was changed to be a kind of a gravel area. The peer review engineer said he preferred that rather than a rain garden. There is a small catch basin. It's actually called it's a dry well here, because otherwise it sheet flows across and then part of it comes down here. There's also, on the new addition in the back, there's a rain barrel added with 2 downspouts. Currently there's screening along here, and even though this is all wooded here, the planning board requested, and it's mostly deciduous and not evergreen, the planning board requested that some evergreens be installed along there as well. So I think those were all the improvements that were made on the site plan. And the planning board agrees, as you can see from the memo from the planner, that in fact we've essentially addressed all of the site plan issues. The planning board, however, has decided now that they're going to decide about the use of the property. And the planning board has a concern, as expressed in the planner's letter, that 2 uses and or 2 principal structures on a site on a lot in the town of Raleigh is not legal. That's not true, as far as I can see from my review of several occasions of the zoning bylaw. There is no prohibition in the town of Raleigh for 2 principal uses on 1 lot. Notwithstanding that, even if there were a prohibition, Chapter 48, Section 3 makes it very clear in the cases that follow, particularly the Watrous case, which I provided to you, that you can have a second principal exempt use on the same property with a different principal use. It's exempt. And so, with all due respect to the planner and the planning board, they didn't want to hear that from me. They wanted to hear it from the zoning board. And so they wouldn't close their hearing. And they sent us back here, which of course we were coming back anyway. So we're here to ask you to make your determination to overturn the building inspector's decision to issue a cease and desist on having a school here for children over the age of 7, as well as the preschool, which of course is exempt. He didn't issue a cease and desist on that. With 2 caveats, 2 conditions. One that we agreed to with the planning board, and that is that there be no more than 60 students on the site. I think that would be required anyway with the building inspector. I think that's what the capacity is going to be anyway. But we were fine with the condition of that. And then also the fire and police chief, and this is the caveat that I wanted to mention earlier, the fire and police chief said that they are fine with all these improvements. In fact, I think the fire chief is very happy about this, except for they wanted to know when it was going to be done before they finally signed off on it. And so our agreement would be, then you can add this condition as well, that all of the improvements related to traffic and parking be done before the opening of school in the fall. So we're fine with that, because the intention is as soon as school is out, these improvements are going to be made. So we would ask the board to overturn the building inspector's determination and allow us to move forward, and we're fine with those 2 additional conditions, and make some kind of finding that the planning board will listen to, if you will.
Okay. As you know, we got a letter from Mr. Baker regarding the use. And so I have couple of questions that I want to ask. In the outlying district, businesses are not allowed. And there are businesses that are grandfathered in the outlying district that exist. But new businesses cannot be established.
Mhm.
So I want to know when this school was first started.
So, I can answer that question. It was started in 2000 and,
2007 when it first started on a different.
no,
property,
what, on this property.
2010.
2010, however, notwithstanding that, this is not a business as defined in the outlying district in the zoning ordinance. This is specifically exempt in the outlying district as a nonprofit educational use. That use is specifically exempted in your zoning bylaw in the outlying district. It's not classified as a business, it's classified as a nonprofit educational use.
Okay. I want to hear from town council on this.
Well, I think there are a number of issues here that relate to terminology in a lot of cases, and the planning board. Have you seen the recent today's memo from?
Got it late in the afternoon, yes.
Regarding an opinion from town council?
Oh, I got this memo from,
No, it's another one.
I-
Yes, that's the one I wanted to
I don't
see.
have, what is that? No, I don't.
Show,
It's an email from the planner.
yeah, show that email, which is an exchange.
Read it, Joe.
Which is just another element here, because I have a number of comments about what we can and can't do for you, what we may have to do, but we don't want to do, at least I don't want to do it. And some of it is because of this most recent email that we got today ourselves.
The top, just the top.
You might recall town council was present at
Yes.
the zoning board meeting last time.
Yes.
And the minutes of that meeting. So, he did not opine, well, your minutes don't reflect this. But I do recall the discussion about the use. He indicated at the time, he believed that the town council said you had the authority to turn it over to site plan review to account for the parking issues heard about. And that, that you could put off the decision pending the site plan review.
There's,
That's true.
Yeah,
That's true.
That's true. I don't dispute that. This all came about, from what I understand, at the planning board, somebody raised the question about two principal uses on the same piece of property.
I understand that.
Right.
But it's quite, with all due respect to the planning board, they have done a great job with this site plan.
Right, right.
There's no question about it. They do not have the jurisdiction to decide the use. Now, I understand that
That's
Mr. Baker has provided a reference to section 7.6.3.1H, where he says the planning board gets to must find compliance with all of the provisions of the zoning bylaw
right.
before they issue a site plan review decision. Well, that's actually not exactly what it says, and that's not true. The planning board, it said, the actual provision says, the planning board will find compliance with provisions of this bylaw, referring to the site plan review bylaw. That's their job. Their job isn't to step into the shoes of the zoning board by any means. If every time somebody went for site plan review, the planning board's supposed to review whether or not they meet the special permit criteria or the variance criteria. That's not their job. It's this board's job to determine use. And Your-
That's correct.
that's right, and you have, in the provision of your bylaw, and I provided this in my initial filing with you, and I think actually even again on this last week, that in section 4.4.2, that's regarding the use of agricultural and residential, but in the use table of the outlying district, section 4.8.1D, the use as an educational facility is allowed in all districts, and there is no requirement that only one use be allowed on the parcel. That's in your bylaw. And I've provided the case law to you. This is not a close call here. This is a nonprofit educational facility protected under Chapter 40A, Section 3. And in the Watrous case, I would just say, in 1995, in the town of Winchester, there was a piece of property, and there was a big house located on the front of it, 20 rooms actually in the big house on the front of it, and it was operated as a two-family house. And there was an old rundown barn in the back of it. And in that barn, the owners of the house wanted to lease the barn space to what? A nonprofit, actually mental health educational facility, to keep a couple of adults and provide educational service to them by what? A nonprofit through a lease arrangement, okay? The Winchester Board of Appeals granted that special permit because they classified it as a modification to a pre-existing non-conforming use, which was later found not to be applicable. The neighbors appealed it. The Superior Court said, oh, I think you're right, 48 Section 3 doesn't allow more than one use on a site because it's primarily a residential suit. And guess what? The SJC said, au contraire. The SJC said, in fact, if you limited single uses where a nonprofit use was trying to be, a nonprofit educational use was trying to locate on a site, you wouldn't have any nonprofit educational uses anywhere. They would be easily exempted, and you would essentially render 48 Section 6, 48 paragraph Section 3 null and void, because it deals with both structures and uses. This is not a close call. I thought we got over this hump at the last meeting, and we were really focusing on whether the site was safe, essentially, traffic and circulation. So I'm confused about where we are.
Well, I think, Mr. Chairman, can I comment?
Yes.
I agree. I think that the advent of this use issue as it relates to the application that's in front of us is not a relevant query relative to us removing the cease and desist as written. The cease and desist was written when there was a real question about the use under the former state as a daycare center.
Yep.
When that use changed and you gave up the daycare center and you became a school, and now we have certification that you're in good standing as a school, the only thing that applies in my mind to that issue is whether or not you are in fact a school. And under 48 Section 3, you're exactly right. You can put it wherever you want to put it. You want to buy another lot somewhere else in town and put a school, you can do it. These were issues that were voiced by abutters, by people in the community. That's the planning board. With all due respect, we trust the planning board to figure those things out. That's their job.
And here they are, right.
This use issue, in my opinion, has come up like with the Sabatini issue, where there became a question in the first of Ken's cease and desist about whether or not it was a valid use, and all they were is asking an opinion. And that to me, which we could come up with an opinion, but it's an opinion. We're not permitting. We're certainly not, in the town of Raleigh, our variance capability is very limited. We're not doing that. For us to take a position on the use as it relates to this application, in my opinion, is irrelevant. What I think, personally, what I think has to be done is, if there is a dispute about the use, someone has to file a cease and desist against you on that basis, then that application has to come back to us. And now we can engage all of this discussion about is it or is it not. I read the case that you cite. I agree with your interpretation of that case. It's not a question of interpretation, it's the court finding. So it's very clear to me that that is the case, that there is the room for two uses, and particularly these two uses on this property. If you said you wanted to also operate a tractor supply service, I think we would all step back and say, well, that's not consistent. But you might be able to make an argument based upon that case. Nevertheless, I think that the problem that's occurred, which is the bottom of this email that you didn't read, is as also from, this is from Christopher Thornton, email also dated today, as you may, to Tom Mullen, Town Council. As you may recall, we spoke a few days ago about the issue regarding two primary uses on a single lot. Before I had a chance to request you provide an opinion to the ZBA regarding the issue, Kirk put together a good summary, which you've seen, of the issue and submitted a request to the ZBA to consider the issue. I'm prepared to consider the issue, and I think you know how I feel about it. As much as Kirk's letter has effectively informed the ZBA of our concerns, I would also like to request that you provide memo to the ZBA regarding the applicability of the existing bylaw regarding single-use accessory use as opposed to two primary uses, which the applicant is proposing. Here's the key sentence. Debbie Egan, Town Administrator, and I have discussed it, and she agrees that this is something that we would like you to look into on behalf of the town. So the dilemma I think that puts us in relative to the whole use issue is that I don't want to take a position on the use issue. Right?
I'm fine with that, I'm fine with you.
I would rather wait for town council, as you say, Don, to give us an opinion on the use issue. But I don't have a debate with overturning the cease and desist on the grounds that you're an educator. You may face another cease and desist, but that's we'll both have to see if that develops.
So so thank you, and I would like that clarification, and that's why I started off in the beginning by saying the question before this board is the cease and desist issue, the cease and desist order issued in September.
That's it.
By the building inspector. We have provided the information to the board that we are a nonprofit educational facility, and now it's an exempt use under your bylaw.
Right.
And we have gone to the planning board as you've requested, and it's a better site. There's no question about it after having done that. And so we would request that you take the vote to overturn the building inspector's determination.
In doing so, I think you have to realize that the planning board may still choose to withhold their site plan approval.
We're not back to the planning board for a month, and so my hope is that now that I know that Attorney Mullen has been asked to provide an opinion, I'm happy about that
Sufficient time.
because case law is pretty clear.
But I would think
Right.
so. I would
Right.
think so. I would think that there
Right,
wouldn't be anywhere for him to go.
right. So he can provide that opinion to the planning board, and I agree it's not the position of the zoning board to make that determination.
Not as this
Not,
application.
no, because that's not the question before you.
Not
We're
the
not
question
here
before
on a variance or anything
No
of that
one's
nature.
complaining about the
No.
2B, it never came up
Right.
before.
Well,
That's right.
the whole issue, as I understand it, is that the planning board doesn't want to finish that unless we have determined for them the issue of two principal uses.
But that question isn't, as the member said, that question isn't before this board. The question before the board is whether or not to overturn the cease and desist order. Mr. Mullen can provide that opinion to the planning board, and we have to go back to the planning board. They didn't close their hearing, so we have to go back to
I
them.
know they haven't.
Right,
We can, if we choose to, we can offer an opinion to the planning board if we want to, unrelated to this action as far as I'm concerned.
Right.
If we wanna take a position on what we think it is or is not, based upon the information provided by the applicant, and anything else we do know, we can do that, but I don't think it has any bearing on this action. So if the planning board says, well, they didn't give us our opinion, they're gonna get the town council's opinion, and I'm happy to wait to let the town council take an opinion. It's just an opinion. They're gonna take that action and say, okay, this is what we got. Then they're gonna have to decide whether or not they wanna go forward and approve it
Right.
or not. If they don't wanna approve it, then you're gonna go to the ZBA and say,
Right.
go to
Right.
us and say, we're gonna appeal that.
Right, right,
Why should it be declined? So we'll get it back,
right, and then you can make.
and then
that-
we'll make
Right.
the determination by issuing a permit under those uses.
Right, right.
Which would be more appropriate status for you to be in ultimately.
I agree.
So, what do you think? What do you wanna do?
Mr. Chairman, I think Tom is correct to articulate it in just a slightly different fashion. I think the applicant is entitled to a decision on their application as it appealed the inspector of buildings decision at the time. Facts have changed, issues have changed. We're now focused on uses, but there is a pending application that deals with the facts at that time, which was, which may now have changed, but nevertheless, I think they are entitled to a decision on that narrow issue. I also happen to agree with both counsel and with Tom on the reading of the Watrous case. I've read it several times. I can't imagine town council coming out with any other conclusion. It's it's pretty
Clear.
It's pretty clear.
Yeah.
I mean, it says, you know, it's under section 3, and we can't regulate it. But that's for down the road.
It'll come up again, but it's very clear that that's the same.
I think that's where it's
conclusion
going, but the inspector, the zoning enforcement officer, the building inspector issued a cease and desist on one set of facts, that was appealed. And if we go back to the origin of the case, I think they're entitled to a decision on that.
Which is all we're granting them. All we're granting them is the opportunity to say, we are a nonprofit and we can be here.
Right.
That's all they've asked for, and that's all we can grant them right now. We can't say, oh, also, by the way, you can put, you can put a kennel in there, because we're gonna
Right.
give you a permit for a kennel. 'cause
I
we
do
don't
have
want-
one question though, but before we close it, it's a little off, but it's based on something council said.
Sure.
You talked about parking and the fact that it was, I think in your opinion, very adequate because of the
What-
number of students and things.
Right.
Doesn't that assume that you're never gonna have after-school events?
No, so, well, we comply with the regulations, so the regulations say that we need to have, I'm gonna get this a little bit wrong. One per, staff and one per 3 or 4 students. And so we meet that requirement. Now, typically you do that because it's like you do a restaurant calculation, so you have 1 per 4 seats, right? So what if there are 4 people that drive and they take up those 4 seats? Well, that's not how you base parking calculations, right? There's an average. And so sometimes there are peak events and sometimes there are not. So we comply with the regulations in town on how many parking spaces we have to have.
So what you're representing is that if you have a school play and you've got students plus parents, you're still covered.
Yeah, usually the kids don't drive. But
Well,
I'm just,
who knows?
not at this age.
These little ones.
Not these. So, yes, we have adequate parking, and I will tell you that we have some off-street parking that they've arranged for at larger events. But now, given the width of the driveway and the actual creation of this lot and these additional spaces, the answer is yes. I mean, we have multiple kids in one family, so.
Okay, I just wanted to bring it up
Sure.
before we
Yeah,
were done.
no,
because
that's a good point. How many kids in the school now?
Right now, there are 42, and the max would be 60. This is based upon 60.
Okay, and how many parking places do you have now?
20, right this current moment,
Well, in the
proposed,
plan, yeah?
I think 26 or 27. I think the requirement's 27. I think it's either 26 or 27, but we need the requirement. And obviously their peer review engineer checked it all out and everything. And that's based upon the 60, not based upon the current 42.
Yeah, I think what I heard voiced was an apprehension about access.
Right.
And safety.
Right.
And if you brought the plan and had an engineer and the planning board who are experienced at this really help you work your way through, and, you know, the fire department is concerned about access from a safety point of view in the event of a fire.
Right.
I mean, they're all signing off on it.
The fire
I'm not
chief-
gonna second guess them.
Yeah, I mean, I've got the emails from the fire chief and police chief. Their issue, he wanted this to comply
That's good.
with the fire, he wanted this to comply with the new fire code, and it does.
Well, I think that's what the community wanted to
Right.
hear, is that there was
Right.
an effort being made to adjust the site
Right.
to the expansion. I'm pleased to hear there's a cap. I was concerned,
Yeah, no,
and we expressed a concern to the
Right.
planning board that where's it gonna go?
Right.
You know? I
So
mean,
we offered to the planning board at the last meeting, there wouldn't be any more than 60. I think that's gonna be controlled by the occupancy permit anyway,
Yes.
but, so it'll be controlled in both locations, so that's fine.
So you could have 40 cars there.
No, well,
Oh.
again, probably if there were multi-child families, probably more than not.
Right.
Well,
No, not
I
everybody
think to
can
differ,
afford it.
you know, parents,
two
working
kids to
parents
school.
take 2 cars to get to
That's,
student
Right,
events.
but-
Well, I'm not disputing that that
Yeah.
occurs, but you know how Pine Grove is
Yeah,
when everybody shows up there.
Overloaded.
It goes out to the street.
Yeah.
But the smaller ones are, okay, so the larger school events are like, are not here, they're held in other locations.
Yeah, the all-school events.
Where
will
there's
be-
all the students,
Are at a different, they're at a different location.
so they
So
might
we're
have
not having.
teas and things like that, where like one class's parents
yes.
come, but not the all-school events. But as an aside, that's not how you do parking calculations
No,
in any
no, and for anybody from in a butter or anybody else that is at all apprehensive about anything you're hearing, unfortunately, we're not the board that can say, okay, put 10 more spaces in there.
Right.
We're not the ones to do that. They're gonna have to go back before the planning board anyhow, and that's the place to revisit that whole conversation if we want. But if they're complying, they're complying.
Right, we comply with the
But
requirements.
they're complying, so if the planning board is satisfied with that, and I think the planning board has added some extra qualifications to the site
Yeah.
in the buffering and whatnot.
Right.
Which you're obviously complying in, and
Right.
I mean, I think it's great, that's what you can do. I think you're probably doing a lot more than you expected when you started out 8 months ago. But that's the way these things go.
I want it safe too, so.
Yeah, of course. But that takes us back to what I think is that we,
Just for, I personally don't wanna see us give a cease and remove the cease and desist until this is all completed. That's my feeling on it. We get a ruling from town council, then we can move forward.
I don't think town council's opinion on use has anything to do with the cease and desist.
Didn't the cease and desist have to do with the daycare?
The cease and desist was issued for the daycare is a protected use, it didn't have to do with that. It had to do with 6 and above.
It was
The
the
six-
aging.
That's right, it's the aging, so the 6 and above is what it had to do with. And so, because we weren't a nonprofit educational, daycare is automatically, you don't have to be nonprofit to run a daycare and be exempt.
Right.
So it was the 6 and above.
Right.
He actually wrote 7 on his thing, but
Yes.
it's essentially 6 and above. And so we satisfied that, we became a nonprofit, and
Right.
so we meet the requirements.
Right.
And so that was the purpose of the cease and desist. Now, we've provided you the most recent certification from the Secretary of State's office showing you that.
Yeah, in my opinion, the town council's opinion on use is not relevant to our action on this case. I agree completely with Bob, and I've read the case multiple times too, just to make, because I'm not an attorney, and you need to be an attorney to really understand what's there and pay attention to what is not just more case law, and here's the events. It's very clear that the conclusion by the court was 2 uses are allowed, and the actual case involves a nonprofit educational institution. So you don't even have to stretch the reason of thought to say it's a direct comparison to what's here. But that's if there's a use dispute. We can offer an opinion, and we can say to the planning board, listen, you know, we don't know what our opinion will be until we hear from it. But I agree with Bob, if Tom Mullen looks at the case law, he can't reach any other conclusion. And then
Except
they're
that
gonna
won't,
have to do it.
except that won't be germane to the application before us.
Exactly,
Right.
it's irrelevant. It's irrelevant to this application and this action. They could still have a use problem, and we may still have to deal with a use debate around this subject. I don't think, given the fact trail that's out there, that you can get anywhere else with it. But it's not part of this decision. I agree with Bob. I think we can issue an action on this
I'll
application.
agree with Tom, I don't think it's gonna make any difference right now. Let it go to the lawyer, town council, and let them decide, help us out there. I'm not a lawyer, so I don't know.
Yeah, well, I think, I mean.
You know, it's not
and-
gonna hurt nothing, what's it gonna change right now?
It's not, I don't think it's gonna change
So then
anything.
let it go.
No, even if,
I mean,
even
that's
if
what
town council says no, we don't have to accept his opinion, we can say, we disagree, and then everyone takes action.
Well, and that wasn't what the cease and desist was for anyway.
Right, no, right,
Right.
it's irrelevant, it's irrelevant. I was concerned that auxiliary subjects.
Yeah, no, I'm fine to shut them away.
I'm sure you are.
Let's just, we need to stop the bleeding here and get to the answer.
I know. Oh, Don, no. That's what I agree with Don, that's what I said. No,
Oh,
I'm agreeing with Don.
Don, I
Wait
thought you
for
said
the-
Tom.
Oh, I did too.
Oh, I didn't say Tom, I said Don.
Oh,
I
I think you
thought
said
you
Dean.
No, I'm sorry. That's what she picked up, I said, no, I was agreeing with Don.
Sounded like Tom.
That's why I said, it doesn't matter. But why not? To me, it doesn't matter, maybe I'm wrong, I'm not a lawyer.
Well, I don't think it's a question of you or me, because I'm not an attorney either, being a lawyer, because it's a subject that's not relevant to
Yeah,
this
it's
case.
just, well, it's my opinion, and we go try, we're gonna,
Okay.
that's all.
Well, here's what I would request, because,
I mean, why does it make a difference right now?
because honestly, it's a financial issue right now. We have to keep coming to this meetings with all due respect, and I love it, I'm being paid.
But you still
but-
have to come back anyway.
Well, maybe not, sir, maybe
Well, if
not.
it's gonna go to town council.
Well, no, because the question before you is not going to town council. The question before you is, will you vote to overturn the cease and desist, because now we're a nonprofit,
Right.
and we weren't at the time. That's the question before you, okay? The question of use is not here. To the other member's point, if the planning board has another determination, and actually the question of use isn't even before the planning board, but if one of the neighbors were to appeal or seek an enforcement through the town building inspector, then that would be before you. Or if the planning board decided to deny the site plan review for some reason, we can appeal that back to you, and that would be back to you. So if there were appeals, on the use question, it would come back to you, but that's not the question before you. So trying to kind of close this chapter so we can finish with the planning board and decide how we're gonna move on is actually really important. It does really matter, because that issue is decided, It's put to bed, we've given you the evidence that shows that we're a nonprofit, and that was the reason the building inspector issued his cease and desist. So we'd like to close that one little piece of it, so we can go back to the planning board and wait for town council's opinion. And if town council issues an opinion that the planning board, says, well, you can't have two uses, then we're back here anyway. But it's on a different issue. It's not on the issue of, are you a nonprofit or not? We're a nonprofit, we've given you that information, that's why the cease and desist was issued. That's the one little question. You're not deciding the use question.
All right, but when that was issued, you weren't nonprofit.
No, we weren't, but we became one.
Okay.
There's no
What
question,
kind
I've
of
never
that?
claimed that we were,
Okay.
but we've remedied
Oh,
that situation.
yeah.
Right, so the purpose of that cease and desist no longer exists. And he can't withdraw it without you saying you overturn it. That doesn't answer the use question, it answers whether or not it's a nonprofit.
Okay.
So it does matter to us, not that we don't
See,
enjoy
yeah.
coming here.
Well, you just call for a vote. That's what you wanna do. I mean,
Well, he needs a motion to call for a vote, I think.
All right.
Well, we need a motion, right? Agreed. Well, I'll move that we accept the applicant's proposal to overturn the cease and desist issued by the building inspector regarding the daycare center issued in August, because the applicant is now a valid nonprofit educational institution, and they have a right to locate anywhere in town.
Second.
Motion's been made and seconded. We'll call for roll call vote.
Aye.
Yes or no?
Yes.
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 No.
I'll go know what you do.
Motion denied.
Could I ask for reconsideration? The board reconsider the vote and allow the withdrawal of the motion and continue the hearing?
That's a procedural issue. You have more of an opinion on that?
Well, as it stands, the case is over. So I guess it would have to be up to one of the two members that voted no to indicate their thought on that.
And can I explain why? It takes 4 members to overturn the building inspector. If you have denied the overturning of the cease and desist, I have to appeal that. And I would prefer not to have to do that if what you're waiting on is the opinion of town council. And so I would respectfully request that you seek a reconsideration and allow the withdrawal of the motion and have the meeting continued.
That will accomplish the same thing if you're just looking to buy time. It
I'll
won't hurt them
agree
as
with
much.
that.
Yeah, I'll go with that.
All right. We'll continue.
Yeah, look,
So would you
I'll
move
change
to
it.
reconsider?
Yeah.
So there would be a vote to reconsider?
Right,
Okay.
you gotta make a motion.
yeah, I make a motion, we consider that, what we just voted against, overturning the building inspector decision.
And therefore move to continue
Yeah,
rather than make a decision.
right.
Second.
Okay. All in favor?
Aye.
Aye.
Thank you very much, I appreciate that. And so it would be continued to,
Next one. What's the date, please?
May 17th?
Okay.
thank you very much.
Thank you.
Can you check and see if everybody signed that?
The moment she said.
Everyone signed? or your attorney, can you fill this out?
You got, excuse me, I'm Brian Cummings. I think I sent you the email certifying the.
Oh, yes,
Yeah,
okay,
yeah,
yes, yes.
yeah. I did, member Levesque get to see that certification?
Yes, it's in the packets, we all
Yeah.
get a packet of it.
Alright.
Yeah, I don't think there are any questions surrounding that,
Yeah.
but we appreciate having that, because we needed that.
That was 17, is that what you said?
Yes.
Yeah.
Thank you.
Is there a motion to adjourn?
Move to adjourn.
Second. Motion made to adjourn.
Aye.
Bye.
Aye.